Hi, everyone. It's Diana, and I'm sitting here with our managing partner, Sandra Ziskin, and the head of our Medical Malpractice Department, Mr. Jeremy Syrtash. Today, we're having a discussion about medical malpractice, types of cases, and what we can do to help you.
People call us all the time, but it's not like motor vehicle accidents. Motor vehicle accidents,
It's like, somebody hit me, I'm hurt.
Yeah, it's easy. It's easy. We know that's easy. Dog bites you, easy. Med mal, we get calls and calls and calls, and I would say out of all, there's only a handful that we can help, unfortunately, because it has to meet very specific criteria. But I will let the guy who knows all about it talk about it.
I have to say, though, working at a personal injury firm, when you go to the dentist or the doctor, like, I'm working Diamond Diamond, they're like, oh, let me make sure I'm thorough with your health right now. Yes, thank you.
When I go to the doctor, I typically don't tell them what I do. No.
You get top-notch healthcare.
I try to be the patient,
Privatized
not the
healthcare.
not the lawyer. But Sandra, you're absolutely right about it. Medical malpractice, it's a subset of personal injury, and it's a type of personal injury, except instead of being injured by a car, you're injured by a medical professional. That could be a nurse, that could be a midwife, that could be a physician. And essentially, one brings a medical malpractice claim, they seek compensation for those injuries. Now, as you mentioned before, it's very different. There's two essential components that one needs to prove in order to be successful in a medical malpractice claim in Canada. Okay. One is called a breach of the standard of care, which means, was there a mistake made? But you need the second component called causation. Did that mistake cause or contribute to the bad outcome? And not every time does someone get injured by a medical professional, does that mean it's negligence?
Right.
And also the vice versa. Just because a doctor makes a mistake, that also doesn't mean that that's the cause of the injury.
I'm super happy that we have it in the firm now because it's one of the things we get called about quite often.
Yeah, for sure.
The problem we have, though, and this is just for all those people who feel they were rejected by us, we weren't rejecting you.
A lot of this are like, sorry.
Yeah, we're not rejecting you, but there's a few problems. So let's just break it down.
Yeah.
Number one is liability. So whether it's a dentist, a doula, a midwife,
Anybody
a nurse,
let's just be clear.
anybody gives you any healthcare, even naturopath, even chiropractors, physiotherapists, anybody.
So anyone falls into that realm.
Correct.
You give healthcare, you submit healthcare, you assist people with their health.
Correct. You're giving advice, you're taking care of a person, you're holding yourself out to give some sort of a health service, whatever it is. You have to do it in a way that is not grossly negligent. Am I saying anything correct?
That's correct. Essentially, any professional who provides medical care, there's a standard, which is how the profession measures whether the harm that was done or the procedure that was done was appropriate or not. So the way that the law assesses whether the standard of care, for example, or a mistake has been made is whether a reasonable doctor or nurse or doula or midwife would have made the same mistake.
Under similar circumstances.
Under exact same circumstances. And that's really the crux of it. And it seems very straightforward, but it's actually quite complicated. In medical negligence cases, you need experts. So me as a lawyer, I have to rely on an expert to advise me if the mistake that was made was below the standard of care. But the standard of care is half the battle, because you could have a mistake, but if the injuries were going to happen in any event, regardless, then you can't we can't get you compensated.
Yeah. So going back for a second to just the liability. So liability has to prove that it wasn't just like a common error or like a side effect that could happen. So, like when you go for an injury or you go for a surgery and they say, you could have this, you could have this. Yeah. That's nothing. Right. They warn you about it and it happens, and it's a generally accepted side effect of a surgery. Nothing
like you may have like, for instance, somebody goes for plastic surgery. Generally, it's like, hey, we're going to put you under a lot of sedation. This may happen, and I've laid out all the issues that may happen. And that just bars them from being liable.
It makes it more difficult.
It makes
I would say
difficult,
one situation I get all the time, and as you said before, I want to help everybody. We want to help everyone,
right?
Yeah,
but
we're big on that here.
But the problem is that there's only X amount of hours in the day to help people, and also with the high bar to be successful in a medical negligence claim, we just can't take every case. And one case that, just going back to your point, is hysterectomies, for example, or a colonoscopy. That's a better example, where every time that someone gets a colonoscopy, the doctors say there's a 1 or 2% chance of a perforated bowel, which means that the scope causes an injury inside the bowel. That's a known complication of a colonoscopy. And the doctors warn a patient that it's a low threshold, but I mean, it happens. And those are types of cases that are harder to prove because, as you said, Sandra, it's a known complication.
Right.
It's a known issue that could arise. Now, that doesn't mean that a doctor could just perforate one's bowel and never be negligent.
Doing it on purpose.
Exactly.
Right, obviously.
And that's
Now,
why,
when you say perforate, they're poking the holes, right?
correct.
Yeah,
correct.
okay.
And that could cause infection, and in rare circumstances, it could even cause death.
Yeah.
And that's why, we as lawyers need experts to assess these cases and tell us, is there a case for the patient or for the client? And we rely on that expert evidence to tell us if we could help you or not.
So they need a before, after. You need some sort of doctor in the same field to say, he did something wrong here.
Exactly.
Or she did something wrong.
Exactly.
So I had a case, and just to give you an example before we move on to the other stuff, where there was a doctor who was removing women's ovaries for what appeared to be no reason.
For fun.
Basically, it was a really extreme
Terrible.
medical negligence
Terrible.
case. He had multiple people. I was working on this case. Multiple people who did it. So nobody in. I'm just giving a very extreme example so you can understand. Nobody in that circumstance, for multiple women, would have taken out the ovaries. That is a clear almost as clear as you can get.
There was no
negligence
cancer,
case.
no nothing.
There was
and
nothing.
And that goes down to informed consent, where the court, in assessing whether there was informed consent for a procedure, is not just what the patient would have done, but what a reasonable patient would have done as well. And as you correctly pointed out, if there's no reason to take out ovaries, then that's more of a straightforward. But what I will say is that there are no slam dunks. Unfortunately, I've seen cases that appear to be slam dunks and they're unsuccessful at trial, and vice versa. Cases that I thought would definitely go to trial that settle, and there's really no rhyme or reason for that other than there's many factors into a malpractice claim and being successful.
You said implied consent. What did you say?
Informed consent.
Informed consent. Can you define that for people, anybody's watching, when they're going to the doctor and having a procedure done?
Yeah. So one goes for a surgery, and I'll go back to the colonoscopy because we talked about it.
Yep.
And the doctor does not tell them anything about perforated bowel, doesn't explain to them the risk of infection, and then that ends up happening. That lack of informed consent could be a basis of negligence.
Okay.
But that's part of the analysis in these types of
Consent
cases.
has to come from the doctor's mouth.
It does not necessarily from the doctor's mouth, but it has to come from. It has to be conveyed to the patient.
So the client basically, before you're signing that you agree to a procedure, the test is, would you have signed had you had all the information? Mm-hmm. So if I went under, and again, going back to my example of the ovaries, would I sign that consent knowing that this wasn't medically necessary? And if it's proven that I would not have, because I need my ovaries to have children, then that's not proper informed consent. Does that make sense?
Exactly. And I've actually had a case where a patient's going in for one procedure and they get another procedure.
But was that because of emergency?
No, this is just the doctor decided to, I don't want to say go rogue, but many times doctors go ahead and do other procedures even though it wasn't indicated. Again, it's another basis of negligence.
Okay, so I know that thing when you have a deviated septum or something, you can opt in for a little nose job at the same time. But if they end up just doing something to your nose while they're not supposed to be doing that, that would be something that would fall under.
I think it really
like a simple example, I guess.
I think the important thing is that it really depends on the circumstance, which is why anytime there's a case, bring it to us, and we'll be happy to analyze it, free of charge, and let you know whether there's merits to the case or not, or something we can help you with.
And then, of course, that's one of the hardest things to overcome in medical malpractice, and a lot of times not the informed consent, the liability, finding negligence. So once we've leaped over that, there's two other components. The first is, of course, damages. So one of the things we always get with medical malpractice, people call us and they say, I could have died.
Yeah.
And unfortunately, and that's true.
You could have died any day.
Correct.
Like just driving.
But also your damages are now zero because nothing actually happened to you because they saved it. So they didn't make a mistake. So for example, I had a client who was given 10 times the dose of something in a hospital while they were staying there, and they were dead for about 60 seconds. They revived them and they're fine. So yes, there was a mistake made. Yes, it was completely negligent, but there's no damages because he's fine. And
there was no prolonged issues that occurred as a result of that.
And I think it's important because bringing a lawsuit is no small matter. I mean, there are something called cost consequences. If you bring a case, sometimes in a case which you just, the example you gave, it could cost more money to litigate that case than to get money for that patient. And, the one thing about Canada is that unlike the United States, obviously there's multi-million-dollar awards here for serious cases, but the awards in the United States are much larger than they are here.
Yes, they are.
And that's a really important consideration in especially bringing a medical malpractice case, because we don't want to bring a case on behalf of a patient or a client for them to, number one, lose, but number two, have to potentially pay their own costs. And that's something that, we take very seriously here.
And also to correct what happened to them.
Absolutely.
Right?
Absolutely.
Also associated with that.
So there's always a threshold for us internally on how big the damage has to be to take it, because these cases are very expensive to litigate. We like Jeremy said, we have to call in doctors and that sort of thing. So the amount of damages that somebody has is always a consideration when we take these type of cases. Mistakes are made. It's an OHIP system. It's a public system. Mistakes are made quite often.
Of course.
Luckily, they don't quite often end up in huge damages. So it's those cases where it's huge damages. A lot centers around, and a lot we've seen, and Jeremy, you can correct me if I'm wrong, is around birth, fortunately or unfortunately. So we see a lot of big damages around birth, improper birthing cases. I'll let you speak to it because you're more of an expert.
Is that you find a lot of success with that? Not success, but like you find that that's something that you would say, yeah, this is something that would interest me.
Absolutely. And I'm not saying this is the only type of case that we would take on, but over the course of my 13 years of doing this, I've represented many special needs children who've been injured at or around birth or a few weeks after birth, and they essentially get brain injuries during the delivery process or before delivery, and that's a type of case where we try to get the child compensation, the family compensation, to care for that child for the rest of his or her life. Right. As you said before, the public system does not provide enough therapy, physiotherapy, speech language therapy, occupational therapy that these children need. And the one way to get that type of care is through a lawsuit. And by claiming compensation through legal action, we get that really life-changing money for that child and that family to enable that child to get the best care possible.